Hey everybody, welcome back to the channel. In today's video, we will be reviewing trial day 27 and 28, and I combined these 2 days because day 27 had a voir dire, and it was to question a couple of the witnesses the defense would like to bring on to the stand that prosecution is not wanting. So that will include interview of Dr. Russell, Dr. Daniel Wolf, Dr. Andrew Rentschler. And then for day 28, we will finish testimony with Nicholas Guarino, Raina Stonebridge, and Dr. Irene Scorbello. Day 27, there was no jury in the courtroom. It was just to discuss as expert witnesses that defense would like to bring onto the stand, which prosecution is not wanting them to be on the stand. And they're claiming it is because of a violation of Rule 14, which resulted in this voir dire. Prosecution is claiming that they weren't given sufficient time to review these experts' testimony. Therefore, defense didn't meet this deadline for submitting this evidence. Mr. Jackson is saying that it's not that he didn't meet that deadline. He didn't have possession or even was aware of specifically Dr. Russell until after this due date. So he's saying we didn't do anything wrong here. We submitted it right after we received this information. So it's not that we were holding back or hiding evidence from prosecution. We turned it over as soon as we got it. So since they as in prosecution wasn't allowed the time to question this expert witness prior to the trial, they're having this voir dire. This person, Dr. Russell, is put onto the stand and questioned by defense, prosecution, as well as Judge Beverly. They all can ask this individual questions. So that is what day 27 is about. And it is with 3 doctors that defense would like to put onto the stand. So that is what we'll talk about here. Dr. Russell is a doctor. She's actually a retired physician. She's had 16 years of formal education after high school. Mr. Lally is asking that she is not to be allowed to have any testimony at all, complete restriction of anything she has to say. She has a long list of positions as a physician, as well as chief operating positions. She's been published about her knowledge specifically on dog bites, and more specifically, dog bites from police officers' dogs. Her work is widely published and can be accessed by all, not just medical personnel. She believes that after reviewing the evidence that was sent to her for review, she believes that they were from dog bites and scratches, and she believes that there are puncture wounds in his clothing from the dog teeth. Beware, I'm going to put up the picture of John's arm that's cut up. She describes that these are pattern from teeth or pattern from a bite, and that you can see that there's an arch there within those wounds, and that you can see the bottom part of the jaw. Those are the marks down there at the bottom. Dr. Russell, apparently she subscribes to the Boston Globe or something, and has subscribed to this publication online for a year now. Mr. Lally feels that she just saw this on TV and wants to be known for her input on this case.
For all those reasons, Your Honor, the Commonwealth is requesting that her testimony in its entirety be excluded from this trial.
Judge Beverly found that there was a violation of this rule, Rule 14, and Mr. Jackson and Judge Beverly really get into this, so let's take a look at that.
Your Honor, exclusion is the highest form of punishment. It's the highest form of sanction that the court has available to it. Just to put a fine point on it, it is a dire remedy. And I know the court has mentioned 2 or 3 times, I'm finding a violation of Rule 14. That sounds as if the court is suggesting or has inferred that we did something wrong. We didn't do anything wrong. As the court learned, I didn't reach out to her. She reached out and said, hey, look, I've got some experience with this.
I asked you that the other day, though, and I was told that you reached out to her through an intermediary. I wasn't told she reached out to you through an intermediary.
I don't know that there's a difference. I mean,
What I was trying to get at, is this somebody who read about this case and said, I want to be part of that? That's what I was trying to get at. I think it was pretty clear, Mr. Jackson. Go ahead, continue with your argument.
okay, I did not misrepresent anything to the court.
I didn't say that.
I take offense at the court's tone that yes, you did say that. You just said that. You said,
Okay.
I just heard the testimony, and it's not what I said the other day. I know a person in Los Angeles DA's office. I received a text message from that person saying there's someone who reached out to me who said I might be able to elucidate on this controversy concerning the dog bites. I then reached out to her. So when you asked me who reached out to whom, I reached out to her through an intermediary, my friend in the DA's office back in Los Angeles County. I was Mrs.
So maybe it wasn't clear what I was looking for. I think it was clear, but go ahead,
Okay.
continue with your argument on this.
My point is, Rule 14 requires a sanction if, in fact, the attorney has done something wrong. In other words, it connotes the idea that we're doing something by actively hiding evidence or holding back evidence or not providing evidence that you know you're going to use at some point in an effort to take a tactical advantage. And the sanction for that is exclusion. I've never met this woman. First time I laid eyes on her was during the process after she flew out here to engage this Voir Dire process.
You led her through quite a bit today. You won't be able to. I mean, she struggled with to what degree of certainty she held an opinion.
Sure, what's the word I want? Medical certainty, very
All right,
high,
so
degree,
the
high degree of medical certainty.
reasonable degree of medical certainty.
Yes, definitely.
She struggled to what she viewed. She didn't write a report. I have to consider all of these things too, as the gatekeeper as to whether she can actually assist the jury. So I'm not deciding this right here.
The way she ended up getting involved in this whole thing is she saw the headline about the dispute between Dog Bite and Karen hitting this person. Since she had the knowledge on it, she felt she should contact them to give some expert opinion on what she thinks about this. And so she went ahead and contacted the DA's office in Los Angeles, California. The DA contacted Mr. Jackson and said, hey, we have this lady here who's an expert in this. She could be of use to you guys. Here's her number. So then that's how Mr. Jackson was able to get in communication with her. So this took place after this due date that Judge Beverly set up to submit all the evidence for review. That is why Lally is saying he doesn't want her testifying because defense just didn't make this due date. So Judge Beverly listened to this, listened to the argument on it, and decided that there was a violation, which we aren't surprised that she decided there was a violation because we see how Judge Beverly rules in this case, and it's always to prosecution's benefit. So she did find there was a violation. However, she decided she would review the testimony and take all of that into consideration and see if she was going to allow Dr. Russell to testify. But we will find out on day 28. And luckily for you, this is a review of day 27 and 28, so you will see what she allows for her testimony. So next, they also questioned Dr. Daniel Wolf, and he is an accident reconstructionist at a company called Arca. He does exactly what I just described. They reconstruct accident scenes to see if whatever it is could actually happen with all the correct mathematical equations and not just guesses. So he would be an expert in that field. He was questioned by all of them. Then Mr. Jackson brought on Dr. Andrew Rentschler. He is also an accident reconstructionist. His credentials were pretty interesting. He was part of there were a couple others who worked with him, but they created a seat to be used in Humvees for the military, because whenever the Humvees go over these bombs, it blows the Humvee up, and the soldiers that are inside the Humvee, their backs are taking the shock from the bomb. So he was one of the ones that created a seat where the seat will take the impact from that force, so the soldier isn't the one absorbing all of that energy. They do reconstruction using test dummies and such to see, is this car safe? Can it take this impact? Whatever. So they are both experts in that. And of course, Mr. Lally is not wanting any of these experts on the stand. Miss Beverly is going to give her ruling on if she's going to allow them, as well as Dr. Russell in day 28. So let's go to review day 28. We start out the day with Judge Beverly giving her decision if she was going to allow those witnesses on the stand or not. As I stated, she did find that this was a violation of that rule, but that Dr. Russell will only be able to testify only on her knowledge of the dog bites and nothing else. She can't be asked anything else. She also said for Daniel Wolf, he can testify. With Dr. Rentschler, he's only going to be allowed to testify with certain things as well. So there are restrictions with these witnesses, but at least we're going to hear a little something from them. With those findings, we move on with the rest of day 28. We continue testimony with Nicholas Gorino, and we pick up where we left on it from day 26 with, if you remember, Mr. Yannetti was looking through the conversation between Karen and Laura. So within this conversation, Karen told Laura that they found John dead, and there wasn't a lot there, but that's what it was. The next conversation he reads is between Karen and John. Within these text messages, Karen tells John she was going to be going home, and that was at 12:55 a.m. And she had texted, quote, "See you later," end quote. And at 1:04 a.m., Karen texts John, quote, "I'm back in Mansfield. The kids are home alone," end quote. Then they played some voicemails. So let's listen to those voicemails.
Ms. Gilman, if you could have the second message.
Yeah, it's 1 in the morning. I'm with your fucking niece and nephew. You fucking pervert. You're a fucking pervert.
And the sixth message, sir, what time was that received by Mr. O'Keefe's phone?
1:18 a.m.
John, I'm going home. I cannot babysit your niece. I need to go home. You are fucking using me right now. You're fucking another girl. She's sleeping next to me. You're a fucking loser. Fuck yourself.
The seventh message, sir, what time was that received by Mr. O'Keefe's phone?
5:23 a.m.
The last and eighth message, sir, what time was that received by Mr. O'Keefe's phone?
6:08 a.m.
Gentlemen, if you could pause there for 1 second, I'm sorry. With respect to this message received on Mr. O'Keefe's phone at 6:08 a.m., from your knowledge of the investigation, where was the defendant, who, if anyone, was with or around her at the time of this message at 6:08 a.m.?
Jen McCabe, Carrie Roberts.
You know, judging by these voicemails, their relationship was clearly toxic. I doubt these two would have been together for probably not much past that year. If they were at the point where they were comfortable talking to each other like this, specifically since these are specifically Karen's voicemails to John, if she was comfortable already talking to John that way, that tells me it was a pretty toxic relationship. Just because it's toxic doesn't mean the person's then going to kill the other person. It's just clearly these people shouldn't be together anymore. If not, if they do plan on staying, they need to get a lot of counseling to work out their issues. Now, I don't say any of that with any disrespect to either of these parties. I have experience being in a toxic relationship myself, and I know that once it gets to the point where you're willing to talk to each other like that, it's best to cut things off. It doesn't mean you're then going, okay, I want this person dead, or I'm going to be so angry I'm going to kill this person. It's just, you know, it's time to cut ties. So I don't think that they would have lasted much longer than a year, but that's just my opinion. So the last thing we hear too about Karen is that her phone connected to John's Wi-Fi at his house at 12:36 a.m. That's a very important time to remember. He then follows up by reviewing information out of John's phone, specifically Apple Health. Apple has some type of way to track a person's steps, just like a pedometer, to give you health information, how many steps you're taking, and so on and so forth. To illustrate John's Apple Health Watch movement and the Google tracking movement on John's phone better, I went ahead and created this map because when they're just reading out the times and stuff, it was kind of hard to follow. I guess I'm just more of a visual learner, so it's just easier if I just make out a map so I can see it, and I feel it would be a little better for you guys as well. Well, anyways, for my visual learners out there. So this is according to John's Apple Health recordings. So Nicholas looked at his phone, and it shows that he's at the Waterfall Bar at 12:11 a.m. and that there is no location data from the time of 12:11 a.m. to 12:21 a.m. However, the Apple Health records 170 steps. And where these steps took place, we don't know. Because right now, all we have is that he's at the Waterfall Bar at 12:11 a.m. And at some point, he ends up over here at Maplecroft. Maplecroft, yes, it is past 34 Fairview. And yes, the Waterfall Bar is right here. So 12:11 a.m., 12:21 a.m. No recording data for the location from Google. But we know he took 170 steps. Maybe he took it in the parking lot. We don't know. Nor do we know if this is even true. This is just according to Nicholas. And the reason why they know at 12:21 a.m. he's at this location, same location here, is because he did a Google search for 34 Fairview. However, interesting enough is his Apple Health recorded him ascending and descending 3 floors. You would then conclude it was probably the stairs in the Albert's home. However, according to Nicholas, he says, no, John was not at the Albert home at this time. He was over here in this neighborhood. And the reason why he thinks that it probably recorded the 3 floors was because this area is hilly. So let's take a moment real quick, and I'm going to show you a little video I created to explain this area. Then we'll come right back to here and finish the timeline. And they're saying that the reason why it said that is because this area here is a hilly area. And so it's not necessarily that he was ascending or descending stairs or even taking steps. It's just, it read that because this is a hilly area. Now, I'm going to stop there and come right back to this. So I'm just going to record this and put this out here just for an example. Here, this is a little section of Albuquerque, New Mexico. And here I put the Google Maps into terrain. And you can see through here, this is actually a pretty hilly area when you're driving down this road. So with that, it actually shows you that it's hilly, right? So let's zoom out. You can still see the hills. Zoom in. It's still there. So this is the street that Karen and John are on, supposedly, when he does the search for 34 Fairview. Now, I don't know what it's like on this road. I don't live there. Someone else who actually has traveled this could give us a better idea. But based off of what we have here in Google Maps, there's no hills here. You can see the higher terrain or hilly area in all these other places. But for this specific road, there's nothing here. So I'm just going to put that out there. And so we're at 12:24. I put a double here because he also claims that John arrived at 34 Fairview at 12:24 a.m. At some point from 12:21 to 12:24, they drove down this way, came down Cedar Crest, past 34 Fairview, did a turn somewhere here, and then came back down to 34 Fairview, which puts him right here. And we don't get any other information. So from 12:24 to 12:31, we get no information on his health data. So not sure what happened in that frame of time. However, from 12:31 to 12:32, he has a record of 36 steps. And as we know, he's already at 34 Fairview. And I put a finish here because this is where Nicholas is saying that that is the last time his phone recorded any kind of steps. And it doesn't record anything until 6 o'clock in the morning when the police pick up his phone. So from 12:32 a.m., it does show him here at 34 Fairview, but that it doesn't record any steps. So I just put a question mark here. So that is the timeline to track from his Apple Health watch and his Google Map location data from his phone. And if you remember, they're claiming that Karen backed up and hit John and, to make this 3-point turn to come back this way. I question that because if we look at 34 Fairview through a satellite, let's look at that. Here's the Albert home. Here's 34 Fairview. So if they had pulled up here, and Jennifer McKay herself said she saw the car slowly moving through to this direction, and then supposedly she made this 3-point turn to leave, why would she do that? Because John's house is over here, 1 Meadows Ave, from here to here. I just don't see a reason why she would need to do a 3-point turn and come back this way when she would be heading this direction anyway. to John's house. According to Google Maps, it takes 6 minutes to get from 34 Fairview to 1 Meadows Ave. So that's 2.3 miles. So at 12:36 a.m., Karen's phone registered that it connected to John's Wi-Fi. So since it was snowing, I'm sure driving wasn't as fast. So we'll just add like 2 or 3 minutes because of the driving conditions. So we'll say it took 9 minutes. So if we subtract 9 minutes from 12:36, so she would have had to have left the Albert home around 12:27 a.m. in order to have made it back to connect to John's Wi-Fi by 12:36. So at 12:31 to 12:32, it also shows that he took 36 steps. So if she would have left the Albert home after dropping him off about at 12:27 a.m., he is clearly still walking around after she left, according to the health data. Now, according to Nicholas, he says that was off and that he compared the health data to the Google searches. And so he says that he was not at 34 Fairview, that he was at this road, and that is where this discrepancy comes in. And this is how basically it's debunked that he was descending any floors at that time. Find out his phone stopped sending data. Maybe it was because of the storm, but at this point we lose data from his phone from 12:12 to 12:20 a.m. Maybe the search was done before that, and that's just when the data reached and started recording again. Now, I don't know why the phone stops reading any kind of health information at that point. I don't know if it's just because it only records steps, doesn't give you any kind of health heart rates or anything. I'm pretty sure it does give you a heart rate because I know someone with this app, and it does give them a heart rate reading consistently. So we didn't get any heart rate information, so maybe his phone just didn't do that. I don't know. Important to know that this app isn't going to give you it doesn't tell you like this person took these steps at this location. It just says this person took these steps at this time. Apparently, an app can use the time from 3 different places in which it pulls the time from. It can be seconds in difference or even minutes in difference in time. Though it says it took place at this time, who knows? If it actually did, it could have been off by a couple minutes. Now we have a difference in time. So either Karen was there with him at this time or she was already gone at this time. We don't know because it pulls from 3 different locations. So we don't know the exact time, even though it's telling us it's this time. Here, if we go back to Jennifer McCabe's phone record, which I've had to pull from old notes, we have in Jen's call log or text log that she texted John at 12:27 a.m. and wrote here. Didn't I say? Oh my gosh, yeah. So at 12:27 is what I had just figured. Karen would have had to have left John at 12:27 in order to get back to John's house to connect to the Wi-Fi by 12:36. So this would actually match when Karen left John there. So at 12:27, Jen messages here, but also at 12:31, she texts, "Pull behind me." But at 12:29, she called John and there was no answer. But you can't just assume, because he was already hit by that time, because at 12:31 she looks out the window and noticed the vehicle had moved, or she texts, "Pull behind me." So clearly there's some times off here. So I have a problem with this health data, and I'm not quite sure why they allowed it as evidence. But if, according to Nicholas, he is saying the steps are off, that they're not reading steps, they're reading just movement. Well, if you're going to question authenticity, then the app and all the information within the app is all illusionary, because if you're going to change what you want out of there, then why can't everybody else change what they want? And I think it's pretty relevant and clear to that point that the app is going to pull a time from 3 different locations in the phone. So that itself is not even accurate. So if we're having all these inaccuracies within this app, I'm not even quite sure why this was even allowed as evidence. I don't know. What do you guys think? We find out that Nicholas received John's phone from actually Trooper Proctor. So with that, we'll move on to Raina Stonebridge. She is the director of the cardiac neuropathy at the medical examiner's office. She said John had skull fractures, said that these fractures can occur from a fall or being hit by a car and landing on the ground, but doesn't know exactly what caused those fractures. There was no cross to any of her testimonies. So we'll move on to Dr. Irene Scorabello, is the medical examiner that Trooper Proctor called a whack job because she didn't want to rule John's death a homicide. She said that John's cause of death was blunt impact injuries of the head and hypothermia, and that the manner of death could not be determined. She said that a blunt object is a wide range of things and gave examples that a microphone could be a blunt object. She said a water bottle could be an object if it was heavy enough. She said the ground could be a blunt object. She said it's anything that does not have a sharp edge to it. So like a knife wouldn't be a blunt object. It could also be a dumbbell weight, yes. She said that the injuries John sustained were not lethal, like a gunshot. She said that the injuries he sustained would not have killed him. She said his injuries were there for a while to allow the blood to continue to flow and pump around his body. She further believes that John was more than likely incapacitated or unable to move into like a warmer place, like a warmer environment, and therefore hypothermia set in and eventually killed him. Mr. Lally was trying to get her to give a specific time frame or time amount in which these injuries needed to take place in order to kill John. She said she wouldn't give a specific time because it could take anywhere from minutes to hours for this to eventually kill him. However, she also further believes that based on the photos, or the limited photos she was shown, and these are her words, limited photos, she was shown that John's body did not travel far from where it is. Now, that's not saying he was not carried there. She's just saying, like, if this is where John was found, he didn't travel far from wherever to end up here, because there was no disruption in the grass and snow around him, or like drag marks. Of course, drag marks could have been covered by the snow by that point. Who knows? She's just, as she said, off the limited photos she was shown. She also said she didn't see any significant signs of an altercation on his body. She said that usually there's like bruises or fractures on a fist on the top of the hand, and she didn't notice any of those type of injuries. She also said that he did have fractures on his sternum. She said these are common when CPR is done, and so she believes that's exactly where those fractures came from. So before you jump on it was from the car hitting him, she says no. She sees these quite often once CPR is done on an individual. So interesting, I think, with her findings that she didn't find any kind of altercation, any significant signs of an altercation. If you're being held down, you're not going to be able to punch anybody, or you're not going to be able to even defend yourself. So what do you guys think about her findings that there was no significant signs of an altercation? How do you read that? I'd like to hear your guys' comments. I'll save my comments from that this time, but I would love to hear your guys' comments. So with that, that is the review of day 28. Please make sure you thumbs up this video, like, share, and subscribe. And I look forward to reviewing day 29 with you. We are almost at the end, so hang in there. See you next time. Bye.